Good evening, team members. Today, we are going to continue with our same series of webinar on SME listing. We started with understanding the eligibility criteria as to who can go for SME listing. Then, we discussed and analyzed about the participants to SME and the process to SME, what you need to do for SME listing. And then we bifurcated it into two: pre-issue, what are the steps to be complied with, and post-issue, what are the activities to be done. Today, we're going to complete this SME series by trying to understand what are the post-listing compliance norms for SME entities. My sincere thanks to Aishwarya for this presentation. These are a couple of legends which we have used in today's presentation: the depository participant, the employee stock option, the further public offer, general meetings, the issue of capital and disclosure requirement regulations, and SMEs, as we all are already aware of. It starts from the miscellaneous provision, which is Regulation 278. Under Regulation 278, you have the provision of further capital issue. Under further capital issue, it clearly talks about what if you are planning to go for further issue when you already have this particular issue activity in place. Is it possible? And if possible, how it is possible? Then you have Reg 279. Like any other IPO, you have the green shoe option facility available. We will see why green shoe option and who is a stabilizing agent and what is the role of a stabilizing agent. How does he control this or stabilize the pricing mechanism in the event of green shoe option. Then we are going to deal with alteration of rights, like your Companies Act, where there is an alteration in the rights of the shareholders. How are we going to deal with the rights of the class of those shareholders, subject to the necessary approval as applicable in the general law parlance. Migration to main board. We know the threshold, 25 crores. If you are going to reach the threshold, then you will migrate from SME board to main board, of course, subject to compliance with all your SME norms. Further issues. You can go for further issues, be it your rights issue, Chapter 3 of ICDR, or Chapter 4, your FPO, or Chapter 5, your preferential issue, or it could be a bonus issue, but the relevant regulations, Chapter 3, 4, 5, as the case may be, shall be complied with when you are going for such further issues. What are the significant disclosures after listing? You have to certainly take a cue from your LODR regulations, and we are going to see what are the mandatory compliances and an overview of the mandatory compliances, because in detail we have covered under our LODR regulation chapter. So we'll see a bird's eye view of what are the mandatory compliances and what are the voluntary compliances. First, the further issue. Further issue, how it can happen when there is this SME listing in place. Is it possible? Yes, it is possible, provided you make relevant disclosures in your offer document. That is, from the date of listing to this particular issue, except in case of ESOS, that is your employee stock option, there is no such additional disclosure required, because employee stock option is something which is going to be a regular event in case of listed entities, and hence that is excluded from this particular ambit. So issuer shall not make any further issue unless specific disclosures are made regarding the total number of specified securities, the amount which is proposed to be raised through this further issue, and such full disclosure shall be made either in the draft of a document or the final of a document. What is the duration between the date of filing of the draft of a document and the listing? So between this stage, from the date of filing your offer document till the stage of listing of your specified securities which are offered through this mechanism, the offer document. Till this stage, if there is going to be any further issue, then you have to comply with this particular formality under Reg 278. Here, the further issue could be your rights issue, QIP preferential issue, public issue, or issue of bonus shares, as the case may be. Now, let's move on to the another interesting topic, which is your green shoe option. Why do we have green shoe option, friends? This is to stabilize the market price after listing. So who is the stabilizing agent then? If the market price falls below the issue price, in order to protect the minority shareholders, that is the individual shareholders who are procuring from the market nominal number of securities. So this stabilizing agent will buy from the market to stabilize the price of these shares. So what is the intent? To establish stability and liquidity on the public offering. You have the stabilizing agent and this green shoe mechanism in place. To stabilize price, it cannot be for a very long period. So there should be some cutoff. So they are giving a cutoff of 30-day period after this particular listing happens. So till that period, it is protected. And how it is protected? Through appointment of all these agents. So first you have to take approval of the shareholders while you are going to establish this green shoe option and for appointing such stabilizing agent. We saw what is this green shoe option and why we have the stabilizing agent in place and what is the intent behind this SA. There is going to be this maximum cutoff period also, which is the 30-day period. So he will borrow the shares, the stabilizing agent, from the promoters, or it could also be the pre-issue shareholders. We are going to see what is the cap in case of IPO, FPO next slide, and to the extent of this proposed allotment, that is very important. So to the extent of this oversubscription, he is going to keep a ceiling on it. So first, shareholders approval is required for this process. Then you're going to enter into an arrangement with this stabilizing agent. You will have an agreement with the stabilizing agent, and the stabilizing agent shall enter into an agreement with all the stakeholders concerned, be it your promoters or your pre-issue shareholders, and the maximum cap, like how the duration is 30 days, the maximum cap is not exceeding 15% of your issue size, which could be borrowed from these stakeholders, be it your promoters or pre-issue shareholders. And the lead manager, again in consultation with the stabilizing agent, shall determine the amount of specified securities which could be over allotted. So he will determine what could be the cap therein, and all these material disclosures shall certainly form part of your offer document. And this offer document shall be in the format as prescribed in Part A of Schedule 6 of your ICTR regulations. Friends, please stop me if you have any conceptual doubt regarding this green shoe option or stabilizing agent. Then who can borrow? As I told you, you have two categories. In case of IPO, you will be borrowing from promoters and pre-issue shareholders. And in case of FPO, from pre-issue shareholders holding more than 5% of specified securities. So there is a cutoff in your further public offer. So what is the IPO? We know when an unlisted entity is going for the first time an issue, it is becoming an IPO. And what is further public offer? When a listed entity is going for any further issue of shares, it becomes a further public offer. And promoters may also lend specified securities to the extent of the proposed over allotment. So that cap is to be determined in consultation with your lead manager. We've already discussed in the past as to how the lead manager assumes significant role when it comes to the overall process from pre-issue, post-issue, and the post-listing compliance formalities of this SME category. And the form of specified securities borrowed, it shall be no doubt in dematerialized form, and allocation shall be made pro rata basis to all the successful applicants. Tenure is 30 days as discussed. So that was captured in our previous slide. And opening of accounts by the stabilizing agent. For conducting this particular activity, there will be an account opened by this SA. A special account with a bank, like how for dividend you have a separate account open. For this particular process to be completed, there will be a special account open for crediting the money which is received from the applicants against this over allotment. So underline that over allotment, please. And special account with your depository participant. Why do you need it with the depository participant? With bank for money, with DB for crediting shares. Here it is crediting the money, here it is crediting the specified securities. Again, specified security could be your equity or convertible securities to be brought from the market during the stabilization period out of the money which is credited in the special bank account. And this shall be, the specified securities which are credited shall be immediately returned to the stakeholders concerned. Who are they? The promoter or the pre-issue shareholder. Immediately, not later than 2 days after the end of. So after the end of this cutoff period, stabilization period, immediately you may have to return it back. Whatever you have borrowed, you have to return it back to them. On the expiry of this stabilization period, if the SA has not been able to buy the specified securities from the market to the extent of the securities which are over allotted, the issuer shall allot those securities at the issue price in the dematerialized form to the extent of the shortfall to the special account with the depository participant. And these SAs shall remit the money with respect to those allotted securities, because in consideration they will be providing the money. Within 5 days of closure of stabilization period, this particular process shall occur, and such specified securities be returned to the promoters and the other stakeholder, being your pre-issue shareholders, in lieu of the specified securities which are borrowed from them. So to the extent which is borrowed, it will be returned to them, and the account with DP shall also be closed thereafter. And any money which is remaining in the bank account after this particular remittance of money shall be transferred. So whatever is the residual portion after completing this entire exercise shall be transferred to your investor education protection fund, which is established by the board, and special account shall be immediately closed. Whatever account we have opened specifically for this particular process, immediately after closure of this stabilization period, you have to close this account. So from then on, if there is going to be any other FPO, you may have to open a specific account for the purpose. Then allotment has happened, your stabilization period is over, whatever borrowed from your stakeholders, you have returned them, and the money is credited to the account, and in lieu of that, the shares are allotted to the specified securities are allotted, and whatever is the miscellaneous you have, after you have closed the special account and also you have transferred the balance to your IEPF. Now the listing process starts. You make a specific application to the stock exchange for listing those specified securities, and in this particular scenario, the provisions of your IPO of Indian Depository Receipts, that is your Chapter 7, will not apply for this particular allotment. Report by stabilizing agent. The specified form for this particular purpose, where the final report shall be laid by this particular stabilizing agent, is Schedule 15. So register shall also be maintained by this SA with details of all the stakeholders concerned, be it the promoters or the pre-issue shareholders from whom he has borrowed those specified securities, and against each promoter and each pre-issue shareholder, how many securities were borrowed. The same shall be like your register of members. You have to make a separate category of register for this purpose, and more importantly, the event date when the transaction has occurred, and the details of allotment which are made by the issuer on the expiry of the stabilization period. So all these details you may have to maintain a separate register. Then comes your alteration of rights. When will you have alteration of rights? When the interest of that particular class holder is getting affected. For example, if I am a preference shareholder, if my dividend right is getting affected or my redemption date is getting changed, then my interest to that extent is getting varied. So what will the company do? They have to seek necessary approval or consent from those set of shareholders whose class of interest is getting affected. Likewise here, the terms of specified securities issued which could adversely impact the interest of those specified securities shall not be altered except obtaining the specific approval of not less than 3/4 of the specified securities of that class. So this is in line with your other class rights, variation of rights of shareholders, or approval by way of special resolution passed at a meeting of the holders of specified security of that class. So if it is going to be a class A or class B, whichever class against which the interest is getting affected, you may have to seek necessary approval in line with this particular provision. migration to main board. As we are aware, if the threshold is likely to increase, the capital post issue is going to increase beyond 25 crores due to various issues that you are revolving, then you shall migrate to the main board. Of course, you have to comply with all the norms under main board regulation, which is your overall ICDR in line with the specific type of issue which you are going to do, and you will comply with all the obligations and the disclosure norms as specified in your LODR as well for a main board. And further issue of capital could be made on satisfaction of the following. One, you have to seek approval from the shareholders by passing a special resolution through postal ballot. Here, postal ballot is mandatory as set out in your ICDR regulations for the purpose of migration from your SME platform to your main board platform. And there is an additional stipulation that the oaths cast in favor shall be at least 2 times the oaths cast against the resolution. Of course, you need to obtain in principle approval from the main board for listing of these specified securities. The entire bunch should get moved and it cannot happen in piecemeal. Any questions? Okay, we will move on. Next regulation talks about your further issue. It clearly says that SME could also make, after this particular IPO, they could proceed with further issues under Chapter 3, your rights, or 4, your FPO, or your preferential issue under Chapter 6, or it could also be a bonus issue in general by complying with the respective ICDR regulations. There is no bar in that. And the various post-listing compliance requirements are broadly categorized into 2, mandatory and voluntary compliances. And mandatory is again only a bird's eye view here. You have to certainly go through LODR regulations and our specific webinar on LODR regulation to see what are the applicable governing statutes or applicable governing rules for this SME platform, because almost all the corporate governance norms of the main board platform will be applicable to SME exchange, and also your financial results under your regulation 33, you may have to do quarterly financial result under main board, but for SME, since they are given lot of privileges and exemption, they could do it quarterly financial result in lieu of half-yearly financial results. That is the only leeway available to them. And over and above that, we are going to see what are the voluntary compliances which they may do. What are the disclosures after listing? You are giving the offer document stating that the use of proceeds will be for your power plant, expansion of your power plant in Gummadipundi. But you are extending this particular proceed use for your power plant, which is going to be set up not only in Gummadipundi but also in Pune. Then what will happen? You may have to certainly say any deviation in the use of proceeds which were already laid out in the offer document by providing additional disclosures. And category-wise variation between the projected utilization as stated in the offer document or explanatory statement of your general meeting, where you will lay out all the material facts of your proceeds and the actual utilization. So if 500 crores was mentioned and you have utilized 400 for your first power plant and 100 for the second power plant in a different set of location which was not specified before, then what under which category this particular variation is coming should be clearly spelled out, and the statement of deviation be given till the proceeds are fully utilized. 500 was your IPO money, 400 you have utilized, and 100 is still underutilized or you are proposing to utilize in the near future. Then you may have to state till the 100 crore. If it is going to be milestone accomplishment, then for every 25 crores you will be providing periodic reporting till that 500 crore is completely exhausted. And such variation explanation shall also form part of your board's report in the annual report. An annual statement for utilization of funds other than those mentioned in the of a document shall certainly be certified by your statutory auditor. Then it shall be placed before your audit committee until the full money is completely raised. So you need a certification backed by your review and recommendation of the audit committee, which has the term of reference of reviewing your financial statements overall. And the listed entity where they have appointed a monitoring agency for the purpose of tracking this particular fund utilization, the company shall submit the same to the stock exchange along with the additional comments or report which they have received from the monitoring agency. There are few additional mandatory compliances like your shareholding pattern. So we all are aware that the shareholding pattern, the company shall certainly provide it to the stock exchange within 21 days from the end of each quarter under your Reg 31. SME platform is no exception to it. So within 1 day prior to listing of securities, you may have to submit. 1, 2, on half-yearly basis. When it comes to main board, you will be doing it on a quarterly basis. For SME, there is again a privilege available. In lieu of quarterly, you will be doing a half-yearly. So only 2 reportings per year within 21 days from the end of each half year. Whereas in main board, it is 21 days from the end of each quarter. And where there is a capital restructuring of the listed entity, pursuant to this, if there is going to be any change in the total paid up capital of more than 2%, then within 10 days of this capital restructuring, it could be your merger, demerger, slum sale, whatever it is, due to which the trigger point will be 2% of your post-issue capital, there is a change, then you owe a disclosure requirement within 10 days of such change. Financial results under Reg 33, in lieu of your quarterly in the main board, here you will be presenting half-yearly financial results to the stock exchange. The timeline remains the same within 45 days from the end of each quarter. And you also have to provide your cash flow statement, which is half-yearly year provision. And other corporate governance norms are the same. Your annexure to the corporate governance report and what will be the matters to be placed before the board of directors and what are the contents to be laid in the annual report as part of your corporate governance norm all remain the same as in the case of main board under your chapter 4 of your LODR regulations. Finally, you have voluntary compliances. The business responsibility report, LODR clearly says that for main board, once you reach that 1,000 market cap, the listed entities, there it is mandatory. They have provided a clear proviso in this particular regulation stating that for business responsibility report in the case of SME entities, it is a voluntary compliance, which means these companies, if they want to provide such report, they may do so. Not only the business responsibility report, but also the sustainability reporting, all are going to be on a voluntary basis by the SME platform. So BRR as governed under your Reg 34 of your LODR regulation. With this, we are concluding this SME listing. More to provide an overview of this particular SME platform as provided in your ICDR, LODR regulations, and more from the perspective of the promoters and the entrepreneurs, how they are viewing this particular SME, which is a boon as discussed in the first webinar. It has a lot of benefits and an easy process to get it listed under the SME platform. With this, we are concluding today's session, friends. Thank you very much. Take care. Stay safe.